Hello friends, how are you? Namaskar. Myself is Dr. Jinesh Soni. I am an advocate. In today's class, we will discuss an important concern regarding the SARFAESI Act. As we know that whenever bank act as per the protocol of SARFAESI Act, it is having the negative psychology, which is usually considered as institutional defensive psychology, by the virtue of which the bank is having certain assumptions. The assumption is that he is having the mortgage over your property, that is your asset. Eventually, the amount is not paid by you. The proceeding of NPA will be initiated. And in case you are having any grievances, you may proceed to DRT for vindication of the grievances. Am I right? So basically, the belief of the bank is inter alia with the preview of SARFAESI Act. So whenever you file a civil suit, the bank is having the view that you could not file a civil suit because it is barred by SARFAESI Act. But there might be exception to that rule. So I'm discussing same with the help of suitable example. Yesterday, I was studying one of the most important judgment of Honorable Bombay High Court. In that case, a case was submitted by Central Bank of India, and ultimately it defeated, not only at the level of trial court but also before Honorable High Court. So basically, we have to understand the factual scope, and apart from that, we have to understand the strategy adopted by the concerned pakshkar or the concerned party, so that if we are having the same trouble, we could easily enforce our right without any worry or without any anxiety. First of all, we will discuss the mood question involved in that case. Basically, an agreement was executed between two private persons. One of them was developer and while other was purchaser. It is basically the agreement to sale of the concerned property belongs to Mr. B. Mr. B is basically the developer and Mr. A is basically the purchaser. Certain amount has been fixed. As we know that when the amount is fixed, it is called the consideration. It could be paid off in whole or in part. When it is paid in part, the amount which is given as advance, it is called earnest money. And the remaining amount could be paid at certain point of time. Am I right? And this time the concerned purchaser had paid the amount through a check. But ultimately it got dishonored. And finally Mr. B has given the notice to Mr. A with a request that to settle the accounts, to give back the possession of the land, and apart from that, the specific request is made that you are not having any right in the land. If you are disposing of the same in the illegal way, the proceeding as per law could be initiated against you. But Mr. A totally kept silence. There was no response from his side. So basically, in that scenario, what Mr. B means the developer, or we could say the owner of the land could do. He could file a civil suit or a civil case to take back the possession and to settle the accounts. So same is done by Mr. B. But during the course of proceeding, he had come to know that Mr. A illegally mortgaged the property to the concerned bank. So basically, the bank is involved, and Mr. A was under impression that by having the proper mortgage, the property is not required to be returned, and ultimately he is with the win-win position. But Mr. A and the concerned bank was wrong in their approach, because the specific case was filed by Mr. B with the specification that there is basically agreement to sale. And as we know that in consequence of agreement to sale, there is only equitable rights, not the legal right. Means the concerned person could not occupy the position of owner. And apart from that, if the amount that is called consideration is not paid, in that scenario, the concerned contract comes to an end. The earnest money could be forfeited, and even though there is a mortgage deed, a subsequent mortgage deed by purchaser or by the equitable purchaser in favor of bank, in that scenario, it is void, and it could not bind the concerned owner, means the actual owner. So basically, when the case was filed, the bank has objected. It is our property. Mr. A has mortgage. Who are you? And if you are having any grievances, you must proceed as per DRT. It is submitted by Mr. C to Mr. B. And more specifically, Mr. C has relied on the protocol of recovery of debt and bankruptcy act, which is most relevant legislation in the state of Maharashtra, covering such scenarios. So basically, we could say that it is having the resemblance with SARFAESI law. But the concerned trial court has discarded all the submissions of the bank. on ground that the dispute is between Mr. A and Mr. B, means between the purchaser and the seller. So when illegally the property has been mortgaged and the rights of Mr. B, means the owner has been affected, in that scenario he is having the right to come before the civil court. The court specified that it is true that the relief cannot be granted, more specifically when the matter involved the application of SARFAESI, because the remedy lie before DRT. But it is not the case of bank that a recovery dispute is pending between the bank and Mr. B or Mr. A. Rather than the case is that the property is agreed to be sold. Ultimately, Mr. A has violated all the conditions. So in that scenario, if the conditions of a contract or an agreement is entirely violated, in that scenario, the civil court is having jurisdiction, the right could be enforced, and when there is no remedy by the bank or against the bank, in that scenario, the jurisdiction would not come to an. And ultimately, Mr. B has been succeeded and the consent court has ordered to continue the trial of the consent suit. You got my point now? So if you are having the said trouble, you may rely on that judgment and could be succeeded in the court of law. And I want to clarify that whenever we fight a case, never lose the hope. Apply the protocol of reverse psychology. The reason being is that they will try their best to put fear in your heart, because they will play in consequence of manipulations, in consequence of dark psychology. Just know what are their liabilities, so that whenever you are going to fight, you could easily submit your stand without anybody. So by the virtue of that judgment, we could conclude five important points. Whenever the bank resists any claim of you, in that scenario, try to obtain the document from the bank and give the proper reply. You got the point now? Am I right? Please note down. Number two, whenever the bank initiate the proceeding as per section 13 subclause 2 of SARFAESI Act, there is no need to worry, give the proper reply. Because sometimes it is seen that whenever you fail to pay the loan amount, in that scenario, the bank usually initiate the NPA proceeding. But in the easy way, the NPA proceeding could not be initiated. They must provide you the option of restructure of the loan, or which is commonly called the moratorium. If it is not given to you, you may submit the objections, and despite the fact that the concerned bank is totally determined that the concerned bank will not rethink or recall a decision, in that scenario, you may seek remedy as per the protocol of SARFAESI, means by filing petition before DRT. You got my point? And apart from that, even though there is 13 subclause 4 SARFAESI proceeding, even though they have taken a symbolic position, despite the fact that you may go for OTS, means one-time settlement. You got my point? Now it is easier now. Point number 4, if the concerned bank manager is a public servant and he internally pressurize you and compel you that you should give the amount at any cost, and he is not willing to consider your urges, and later on he submits that he could help you in lieu of bribe, in that scenario you may adopt the protocol of section 7 of Prevention of Corruption Act. You got my point now? Just go for a trap. Do not restrain yourself, because he is the competitor. And as far as the Potter's 5 forces are concerned, it says eliminate your enemy. So if the bank manager is working as the enemy or as the competitor of you, it's a time to eliminate him. You may adopt any recourse which is permissible by the law, so that he could teach a lesson to interfere in your way and by causing the obstruction in an illegal way. You got my point? Am I right? And last but not least, whenever you are having right, just enforce the same. If you're not going to enforce your right, you're going to play with your own psychology. Do not try to be the self-obstructing in your way. It's a humble request to you. So see you in the next video. Till then, Jai Hind, Jai Bharat.